Hi, Eric Lee here again with Equity Real Estate and the Elite Agent Training Program. I'm the principal broker for Equity Real Estate in Utah. We're the largest brokerage in the state by volume, closing last year we closed as much as second and third place combined. So a lot of experience here that I want to bring this video to you. And this is part 2 of my understanding earnest money. So again, this is in relation to and in response to a video that I saw earlier today by a competing brokerage that was just a very, very basic statement on a little tiny video they did on earnest money, and it was not enough in my opinion. We have to have a better understanding of this. So this is the part 2. Part 1 you can go watch later. You can look at that on my channel. But after acceptance of the REPC by the buyer and seller, the receipt of the earnest money by the brokerage shall have 4 calendar days in which to deposit the earnest money into the brokerage real estate trust account. So it is a given here that the earnest money will be deposited into the brokerage real estate trust account. Now, every brokerage is required by law to have a brokerage real estate trust account, and the purchase contract here says that the earnest money will be deposited into that trust account. Couple things that I don't like about this though, all right? And I'm fighting with other agents and other brokers all the time on this, so I'm going to share some stories with you. But here's a couple of things that I don't like. First of all, you've got 4 calendar days to get this collected, because you look at this bold part, right? After 4 calendar days after acceptance, earnest money has to be collected. And then the brokerage, after collecting it, has 4 calendar days to get it deposited. So it could be day 8 before you know if that earnest money is really there. Maybe they deposit that check and it bounces. We don't know, right? We have up to 8 days to have that deposit, 4 days to receive, 4 more days to deposit. Okay. So that is one demerit. It's a small one, but that's one demerit against holding it into the brokerage trust account. So I want to take you to another form. This is called the deposit of earnest money with title insurance. Now, we like this. This is our company policy that we prefer to have it here. Of course, we have our trust account. We can hold it there if we want to, but it gets vilified so much. This form does. And I'll tell you why it's vilified and why we prefer it. First of all, let's look at the difference here. This just says that we're going to hold the earnest money deposit rather than holding it in our brokerage trust account. We're going to hold it with the title insurance company, which is a third party to this transaction. Now, on the surface, you would think, well, yeah, that's better, right? It's a third party. Why would we want our earnest money held with the brokerage, with either one of the brokerages? That doesn't seem like it's very well protected. And in fact, I've heard from other brokers in other states. We're in 22 states right now. I believe we're the only one that does this practice. Everybody else thinks that's insane. That is so much risk for your client there. However, this is what we do in Utah. We hold it in the brokerage trust account. Now, why is there such a pushback when it seems like it would be safer held with a third party? The pushback is this big attention section. And it says buyer and seller advise that the title insurance company may require through separate written instructions that both the buyer and seller mutually authorize disbursement of the earnest money deposit, even if the real estate purchase contract states that no additional written authorization is required, which may result in additional delays and costs for either party to receive the earnest money deposits. Okay. And then it just says that the Utah Division of Real Estate has no authority over the title insurance company and their practice to release or disperse the earnest money. So basically it says here that even though the purchase contract says that the earnest money is going to be deposited with the brokerage, we're going to change that with an addendum, which is fine. It's all legal to do. Change it with an addendum, and we're going to hold it with the title company. But both buyers and sellers need to know that since it's being held with the title insurance company and they are not bound by the same rules, that they might have different requirements in order to release it. And they typically do. They typically do require that both buyer and seller sign something. Now, let's jump back to our purchase contract and see one instance where this matters. And then I'll go into story time so you can understand why our stance here at my company is that we prefer it with the title company. Okay, I'm going to jump down here to this due diligence section. This is a very simple one. It's the most common one. So let's read down here that, if we check that our offer is conditioned upon the due diligence section here, as described, and the buyer has a right to cancel. So it says if the buyer determines in their sole discretion that the results of the due diligence are unacceptable, the buyer may either, no later than the due diligence deadline, cancel the purchase contract by providing written notice to the seller. And here's the key words: whereupon the earnest money deposit shall be released to buyer without the requirement of further written authorization from the seller. So that's the key part that we're talking about. The purchase contract says that if we cancel prior to that due diligence deadline, with any reason, it's in the buyer's sole discretion. We don't even have to disclose the reason. In fact, we shouldn't be disclosing the reason, because that could be considered a violation of fiduciary duty under the confidentiality concept. So we're going to, this buyer's going to cancel. They don't have to tell the seller why they're canceling, and they get the earnest money back without requiring further written authorization from the seller. And that could be a great thing for the buyer, right? Here's the challenge, and here's why I don't like this. All right. Agent comes in to me. I'm the managing broker. I'm holding the earnest money in my trust account. And this happens, by the way, all the time. And in fact, a couple of years ago, I had this happen, twice in 2 weeks. So each week this happened, and different brokers handled it differently. We were representing the sellers in this case, but I'll tell the story as if I were the buyer. So my agent comes into me. He shows me the purchase contract, and he says, we're canceling. It's prior to due diligence. I look at the contract. I look at the calendar. Sure enough, it's prior to due diligence. The due diligence box right here is checked, and I've got a notice of cancellation from the buyer. Everything looks in order. And so following these instructions here, I can release it without requirement of further written authorization from the seller. Here's the problem. Most brokerages simply do. Okay. They release it without requiring further written authorization. Not only do they not get further written authorization, they don't ask questions. They don't ensure that they're getting the full story of this. They don't dig a little bit deeper. They just sign a release. Now, if that release is $1,000, no big deal, right? If something's wrong, the brokerage could, pay for that mistake themselves. But what if the earnest money was $100,000? Then it's a big deal, right? And even if it were $1,000, shouldn't it be treated correctly, no matter what? I mean, that's somebody's earnest money. It's important. So in this particular story where we represented the seller, here's the rest of the story that buyer's agent did not tell their managing broker, but the seller did tell me. And they called me and they said, we think we have a claim on that earnest money because that earnest money was not deposited by day 4, which is required in the contract. That earnest money, in fact, after day 4, we asked for it over and over again. Where's our earnest money? And it wasn't deposited until day 9. And then on day 10, we got an addendum that was changing all different terms of the contract. We rejected that addendum, and then they canceled on us. Well, we think we have a claim on that earnest money because it wasn't turned in until day 9. So we jump all the way back up here. We look at earnest money, and it says after acceptance, or agrees to deliver no later than 4 calendar days after acceptance. And they didn't get it turned in until day 9. Folks, that is what we call, if we jump down here, that's a buyer default. Okay. The buyer has not performed on their contract as they said they would in the contract. And so when I contacted the buyer's broker and I gave them, as the old Paul Harvey fans, if you remember him, here's the rest of the story, right? When I gave her the rest of the story, she's like, oh, wow. Yeah, I think you might have a point, but I'm going to call my attorney just to make sure. So she did the right thing. She called her attorney. She hadn't yet released the money. I caught her quickly enough as the listing broker. She called her attorney. The attorney said, they're correct. The buyer has, or the seller, has a claim on that earnest money because it's a buyer default. They didn't perform according to the contract. And so, because I had caught her prior to her releasing it to the buyer and given her the rest of the story, our seller was able to get that earnest money as they should have. Now, that doesn't typically happen. And in fact, the very next week when this happened again, different brokerage, I called the buyer's broker and I said, we've got a claim on this earnest money. And the buyer's broker said, oh, and I could tell he was like, oh, shoot, I've kind of stepped in it. But that's not what he said. He said, let me talk with the buyer and find out. So he did. And I called him a couple weeks later and he said, we're still working on that. The buyer's trying to work it out. And it was 2 months later. And I said, look, this has to be resolved. So we're waiting 2 months, and it was held in the brokerage trust account. And I think, even though he never admitted it, I think it took too long, or it took that long because he had released it without getting the rest of the story. And because it was only $1,000, magically, when I said after 2 months, look, this has to be fixed or we're going to have to report it, all of a sudden we've got $1,000 check waiting for us. And I'm pretty sure it came from that broker because he realized he had mishandled it. But again, what if it were $100,000? What kind of a horrible business practice would it be? And I say horrible because it would ruin your business, right? I mean, that's horrible for business. It's a horrible business practice to not ask questions. All right. It's not horrible to hold it in your brokerage trust account. That's part of this contract. It's allowable, certainly. But it's horrible not to ask follow-up questions, not to make sure you're getting the rest of the story. And because of the language in the purchase contract where it says that you can release it without requiring further written authorization from the seller, most brokerages don't ask those questions. They look at the contract, they say this is a done deal. And I've done that. I've been in leadership trainings and stuff in rooms full of brokers where it was all managing brokers, owners of their own companies. And I've given them this scenario and I said, would you release it with the story that this buyer agent brought to you? Every single person in the room said, yeah, I'd release it. And that's what happens. Okay. And they don't say, you know what, I'm going to require, because there's a separate form that we can ask for, which the title companies require, which, is a form that both buyer and seller sign and say, yeah, we understand that, there was a forfeiture here of the earnest money. This is where it's going. It's going to the buyer. It's going to the seller. Everybody signs it and everybody's on the same page. And if one of the parties isn't willing to do that, then I actually get on the phone with that party and I call them up and I say, okay, it looks like there's a default here on the contract. I want to make sure that you're understanding the same thing that I'm understanding. And I get the rest of the story. And maybe then I can go ahead and release it from my trust account if I'm holding it there. If they have an incorrect understanding, I can educate them and get them to sign the form. Every once in a while, somebody will just be really stubborn and say, no, I'm not going to sign it. I know I'm wrong, but I don't want to make it easy on people. And then, of course, I can get it released. But I've also talked with title companies, and they said, as the managing broker, if I send them a written statement where I accept full responsibility for it, and I state in there, I've had a conversation with the party not receiving the earnest money, they've admitted that they're wrong, and they just want to make things difficult. So I'm releasing it, or I'm authorizing it to be released, and I'm accepting full responsibility. And usually title companies will work with me on that, so I can get it released. The important thing here is the reason why I don't think it's a bad practice to hold it with title is because title does follow their rule of getting written authorization from both parties, meaning that the full story is being communicated. And with brokerages, because of this language, most of the time they are not getting the full story, and we have a greater likelihood of that earnest money being mishandled. So a little bit of a longer video, but I hope it was valuable to you and gives you a little bit more in-depth understanding of earnest money, the different options that we have up here of either holding it in the brokerage trust account or using this deposit of earnest money with title insurance company addendum and holding it there. Thank you.